We all worry about our time because we each think that what we're going to say is the most important.
Mine was the most important.
Mine was the most important.
You're going to hear why mine is the most important. I should tell you that in preparation for coming here, we do meet about 2 or 3 times to try to focus on what is in your material. So, for example, if we were going to talk about mortgages or teach the mortgage course, it would take in law school a minimum of 10 hours. So what I have tried to do and what Sid and Craig have tried to do is focus on the materials that you have and try to explain those materials. Now, one thing when they were talking about an introduction of us, the 3 of us have been practicing a long time, and we all carry on an active practice. And even though they may deny it, the 3 of us really do not only love teaching, but we love the practice of law.
We love the law, not the practice of law.
I love the practice of law. Mortgages. You've heard about Craig talking about real estate transactions. There's very rarely a real estate transaction without a mortgage. In residential property, people cannot buy homes mostly without a mortgage. With respect to industrial or development, developers buy property with mortgages. And mortgages become really crucial because if there is ever a recession, law firms become very, very busy, not in the buying and selling, but enforcing mortgages. So to me, it is very important that there be an understanding of the rights and obligations of an owner, rights and obligations of a lender, what are their remedies, what could they do when there's a default. So we start off firstly, what is a mortgage? A mortgage is simply security given by the borrower for a promise to pay money to a lender who is lending the borrower money. In your material, they spend time. They want you to know the terms that I use for the borrower is mortgagor or chargor. The lender is the mortgagee or chargee. And we tend to use them interchangeably. What does every mortgage contain? In every mortgage, you're going to have what is the principal amount? What does the borrower owe? What is the interest? How much interest is paying? And in most of the times, you'll have a fixed rate of interest, or you'll have now what is called a floating rate. In other words, banks now lend money and say, we're going to charge you a percentage, 1% over prime. Prime goes down, you pay a little less. Prime goes up, you pay a little bit more. From a practice point of view, when clients, you're not far from being lawyers, and clients are going to ask you, and this is away from your material, clients are going to ask you, what should we take? Is a fixed rate or a floating rate? The fixed rate is 4% or 3%, and with the floating rate, it's 2.5%. What should you do? And in my opinion, that's an answer. You explain the benefits and the risks of either one, but you never give the answer. You let them make a decision. In residential mortgages, there's a term used in your material. It's called the blended. In residential mortgages, most payments made by the borrower are made monthly. They are the same payments made every month. That payment includes principal and interest. That's called a blended payment. Each month, The principal's a little higher, the interest, because as each payment comes in, part is applied towards principal, part is applied towards interest. So the term blended is used in your material, and in your material it says that when you use the term blended, you should always say calculated half-yearly, not in advance, or yearly, not in advance. That is really a method, what the courts have said, and this legislation, that is really to let the borrower know how the interest is being calculated. The word amortized. There was an example in your notes. It says a blended mortgage, a mortgage having a term of 5 years, amortized over 25 years. What does that mean? Well, let's say it's a $200,000 mortgage, and let's say you're making monthly payments every single month. And at the end of 5 years, that's when the mortgage matures, the mortgage is down to, let's say, $185,000. That is the amount that the borrower owes to the lender because the mortgage has matured. So what does the term amortized mean? Clients come in and think, geez, my mortgage is 5 years amortized over 25 years. That means I have 25 years. It doesn't mean that. Amortized means if those payments were made for 25 years at the same interest rate, it would pay off the mortgage. So what you have to know is the term of the mortgage. That's when the principal amount is outstanding. It's not in your notes, but we refer to it in practice. It's called a balloon payment. Mortgages. If you're acting for a borrower or lender, you must know whether a mortgage is open or closed. Craig talked about a situation where the vendor, purchaser is going to pay the vendor the money, the vendor is going to pay off the mortgage. And the vendor, when he sells the property, when he or she sells the property, the vendor checks with the mortgage company and says, how much do I owe on the mortgage? Mortgage company says $150,000. That's what the vendor thinks he owes. The vendor now is going to get paid from the purchaser and pay it off. But let's say it was a 5-year mortgage and this was the 2nd year into the mortgage. The lender says, hey, this is a closed mortgage. You've got to pay us a penalty. And the penalty could vary for the lost interest that the vendor is going to suffer. It could be an open privilege where it says you could pay 6 months interest, but always make sure that you know the difference between open and closed. If the borrower wants to pay off that mortgage and it's a closed mortgage, he or she is not going to be able to do it. So I'm trying to stick to things that are in your notes. Your notes refer to, and this is very important for you to know, not only for your exam, but in practice. Banks now, because there's such competition to lend money, are now lending money to residential people for 10 years. In other words, having a term of 10 years, that you're going to be fixed, that you don't have to pay it off in 5 years. Right now, the standard or the typical mortgage for residential is a 5-year term. Now they're giving 10-year term. The interest may be a little bit higher, but what there is to protect a borrower, if the borrower is an individual and not a corporation, and the borrower is borrowing, let's say, $300,000, and it's a closed mortgage for 10 years, which means the borrower can't pay it off until the maturity of the mortgage, There's a section called Section 10 in the Interest Act and Section 18 in the Mortgages Act. They basically say the same thing. Despite what the mortgage says, despite what you contracted for, that borrower has a right to pay off that mortgage after 5 years with a penalty of 3 months' interest. So suppose the rates were 5% for 10 years, and in the 6th year, 5.5%, rates have gone down to 3%. And the borrower says, you know what? I want to pay this off. And so even though it's a closed mortgage, that borrower has the right, as long as the borrower was an individual, not a limited company. So that's very important to know, again, for practice. If a client ever wants to take out a 10-year mortgage but wants the flexibility of having a right to pay it off after 5 years. So that's basically a mortgage. What is most important is, what if there's a default? What if the borrower runs in, there's a loss of job, the plants are moving, a matrimonial dispute? What are the rights of the lender? Lender has a number of rights. One is the lender has a right to sue the borrower who signed a promise to pay. The borrower said, I promise to pay this amount of money. The borrower is not paying it. The lender has a right. In every mortgage, there's an acceleration clause. So let's say it's $200,000 is the mortgage. The amount of arrears are $5,000. The mortgagee has a right to say, I want my whole $200,000. I don't have to sue you just for the arrears. I want to sue you for the whole amount that is outstanding. That is called an acceleration clause. So there's the right to sue. The most common right that a mortgagee uses in the event of default, and the one referred to most in your notes, is a power of sale. The mortgagee doesn't have to go to court. All that happens is there's 15 days in default. The mortgagee only has to send out by registered mail a notice of sale, giving the borrower 35 days to pay that whole amount that is outstanding. And after 35 days, that lender has a right to sell the property. Imagine that. 15 days in default and 35 days notice, and your property that you're living in with your family and your children, the mortgagee has a right to sell that property. What's the right of a borrower? Could I hit that? Let me just finish that, and then the right of a borrower, and you can't contract out of this, the right of the borrower is to pay those arrears at any time, not just during the 35-day period, until the lender sells the property. So if the lender, after 35 days, lists the property, is going to market the property, and the owner says, I've got the arrears, has a right to pay those arrears, pay the lender's costs, and put the mortgage back into good standing. The term sale, in your notes it says until the lender sells the property. It doesn't mean until closing. It means, as Craig said, once the vendor, the mortgagee, enters into an agreement to sell the property. I'll take that question. Pardon?
You answered it. I was wondering if it had to be the full amount or just to pay it back.
Okay, thank you. One of the In order to sell a property, though, a mortgagee needs to take possession. Who's going to buy a property if the owners are living in it? So a mortgagee has a right to take possession of the property. Interestingly enough, if the property being mortgaged is a plaza, it's far easier to do. All you have to do is you write to all the tenants and say to the tenants, pay the rent to me, the mortgagee. We have taken possession. And all you have to do is send out a notice. In a residential property, you can't just go and physically pick up the people and force them to move. You issue a statement of claim for possession. So you have a right of possession. If there is a power of sale, the mortgagee has to act properly. They have to advertise the property. If the loan is, let's say, $200,000 and the property's worth $300,000, the mortgagee can't just say, well, I'm going to sell it for $200,000 and get my money. The mortgagee has to act in good faith and take reasonable care to get the best price that is available when the mortgagee wants to sell. So suppose the amount owing is $200,000. The mortgagee goes to sell, advertises, acts properly, sells the property, and gets $250,000. That amount, over and above the debt, is called the surplus. The surplus is paid back to the owner, or if there's a second mortgage, to the second mortgagee. What if the debt is $200,000 and all the lender gets is $180,000? The lender could sue the owner for the deficiency. Because this is mentioned in the notes and because I've been teaching at Osgood for, I think it's been 37 years in mortgages, and because it's something that most owners don't understand, there's something about our law that, in my opinion, sooner or later needs rectification, is this. A mortgagor has a mortgage for $250,000. It's a closed mortgage. It has, let's say, 3 years to run. The mortgagor, the owner, wants to sell the property to P1 for $300,000. Doesn't want to pay off the mortgage because it's a closed mortgage and it's a good interest rate. The purchaser, they could enter into an agreement where the purchaser assumes the mortgage. In other words, the purchaser says, I'm buying this house for $300,000. I'll take over the payments of $250,000 and I owe you $50,000. That's called assuming the mortgage. Here's the key. Suppose there's a recession. Suppose P1 can't make the payments. Suppose now the mortgagee has to take over, and the mortgagee now sells the property because there's a recession for $220,000. The mortgagees owe $250,000. All the mortgagee got is $220,000. That means the amount owing to the mortgagee is $30,000. That $30,000 is called the deficiency. Where's the mortgagee going to get it? Well, one thing is the mortgagee could sue P1. There's a section in the Mortgages Act that says, and this is in your notes, even though there's no privity of contract, even though P1 didn't sign with the mortgagee, by assuming the mortgage, P1 is obligated or can be sued. But the mortgagee says, wait a second, P1 couldn't make the payments. P1 has no money. I'm not going to get anything from P1. P1, this young couple have lost their jobs. What about the original mortgagor who sold that house a year ago? Is that mortgagor still responsible? Well, who promised to pay the mortgage? That original mortgagor. That original mortgagor is still responsible for that debt, even though that property had been sold a year or 2 years earlier. Your notes talk about the fact that sometimes in the negotiation of a mortgage, you should make it recourse or non-recourse. And unfortunately, we never do that with a residential property. When it's a multi-million-dollar loan and it's wealthy borrowers, they may say to the mortgagee, if we sell to a purchaser approved by you, we want off the hook. That is called you're signing and with limited recourse. So remember that the person who is selling is still responsible for the payments of that mortgage. The mortgagee has a right to get judgment against one or the other. I am not going to talk about what happens if P1 sells to P2 because that's a whole different theory and more law, and it's not in your notes, so I am going to avoid that, but this is not the whole mortgage course, and one day you may have to look into what happens if P1 sells to P2.
So all of this is just in the situation where a mortgage was assumed?
Pardon me?
All of this would apply only in the situation when the mortgage was assumed?
I'm sorry, I'm sorry, could I speak to you after?
Yeah, sure.
Another remedy. By the way, if a mortgagee ever sells and doesn't act in good faith or doesn't take reasonable care, a borrower or a second mortgagee has the right to sue for what is called an improvident sale. So another remedy that your notes refer to, which is very rarely used by practitioners, is that the first mortgagee says, you know what? I don't want to take a chance and be sued. I don't want to just issue a notice of sale. I could apply to the court and go judicial sale, in which the court supervises the sale. You get every step of what you're doing approved by the court. So that is called a judicial sale that the mortgagee goes through. That's in your notes. The other remedy is the mortgagee says, you know what? I'm going to foreclose. I want to become the owner of this property. If the mortgagee forecloses and then later on sells the property for a loss, by foreclosing, the mortgagee cannot sue the borrower for the deficiency. But let's say the mortgagee forecloses, the amount owing is $200,000. The mortgagee keeps the property for a year or so. The mortgagee has foreclosed, now sells it for $350 and makes a huge profit. The mortgagee could keep it. Once there's a foreclosure, the mortgagee becomes the owner and has accepted the security in payment of the debt. A couple of things I want to mention that's in your, is that including the extra time? You gave me the extra time? But I could take extra time because you took extra time. Yeah, I want to refer to a couple of things that the notes speak on. A mortgagee in a mortgage can't put in a clause saying you cannot sell. What they have a right, what they do often do is say you cannot sell to a purchaser unless we approve of it. And if we don't approve of that purchaser and you sell, we have a right to call the loan. In other words, to ask for the whole payment. That is called a due on sale clause. And the most important thing that I do want to talk about that's in your notes and hard to explain and hard sometimes for clients to understand. A conventional mortgage, banks have a right under the Bank Act, and certain trust companies and financial institutions have a right to lend up to 80% of the value of the property. That is called a conventional mortgage. So the borrower has to put in 20% of the value of that property. So if a borrower is buying a house, let's say for $300,000, the mortgage or the person could apply and get a loan for up to 80% of the value. But what if the borrower only has 10%? $300,000, the borrower only has $30,000. Well, the banks can't lend unless the mortgage is insured. And this is a section in your notes that I thought I should explain. What the government has said in an act called the NHA Act, what they have said is we want people that may not have the money to buy a house and have the 20%, we want you, the banks, to lend them the money. And we're going to insure you. We will ensure that you won't suffer a loss. And who pays the premium? The borrower pays the premium. So the borrower pays the premium, and the reason I say it's so important, it's called an insured loan. And so often clients come in and they know they're paying a premium, which could be fairly high. It's added on to the mortgage debt. And we're calling it an insured loan, and later on they lose the job. Or later on there's a medical catastrophe, and they say, well, our loan is insured. And you say, no, it's not. You're not insured. It's the lender that's insured. But they say, but we paid the premium. And say it's only the lender. So an insured loan means that the banks can lend more than 80% because the loan is insured by CMHC, Canada Mortgage and Housing Corporation, and there are certain private companies that have been approved by the government that can insure loans. But that's an insurance to the lenders. I try to touch on, as Craig.
So if the lender gets paid the debt, why does the borrower have to pay it?
Who does the borrower have to pay?
The borrower, it's such a good question. So the borrower thinks the debt is paid off, but when CMHC pays that debt, CMHC is subrogated to the rights of the lender. And unfortunately, and what always surprises me, quite frankly, but it's they go after the borrowers for the deficiency. They do go after the borrowers. So when that person, mortgagor, signs that covenant, there's a very big responsibility. The mortgagee has rights, but so Do the borrowers, as I say, if they could get the arrears, they could always pay the arrears before the property is sold, or if there's a foreclosure before there's a judgment obtained. If anybody has any questions, we're all going to be available after. Is there a break now?
15 minutes.
A break now for 15? Well, Sid will announce the breaks because he's running the program.
15 minutes.
That's why he ran so late.
Vision control. That's the Planning Act lecture. It's about Section 50 of the Planning Act. Now, you've got your materials. That's a paper I wrote probably about 30 years ago, which has been revised in bits and pieces. You've also got those fancy PowerPoint things that look like this. You can follow along with those, or you can follow along off the screen. If it helps, you can make notes on them, whatever you want to do with it. I'm going to take you, unfortunately, very quickly through that paper so that you understand it, because my guess is it's gibberish without understanding what's going on. So let's start. Why Section 50 of the Planning Act? The purpose of Section 50 of the Planning Act is to prevent the subdivision of land, or the division of land, into parcels of land that the government does not approve. If you can imagine having a big hunk of land and arbitrarily putting in roads or dividing it up in any which way you want, so that there is properties that are landlocked, properties that have no access, no provision for services. The government doesn't want that. So what the government has done is they've enacted Section 50 of the Planning Act, which is designed to control, the government control, the division of land in Ontario. That's the purpose of the section. What's the effect of contravening? Now, everybody worries about the Planning Act. I mean, we spent so much time over one section of one statute. We've mentioned Planning Act at least a half a dozen times already today. Why the concern about the Planning Act? Subsection 21, and this is probably the only bit of real estate that you were going to be talking about today that is statute focused. A little bit on estate administration, but the rest of it is all practice. You know, we're not talking about a whole lot of statute in our presentations or law. It's practical. This is all about statute. Subsection 21 says, in nice lawyery language, that if you contravene the section, you do not acquire an interest in land. The document, for the purposes of creating an interest in land, is void. So the deed or transfer that contravenes the act is not effective. Buyer does not get title. The lender does not get a valid security interest in the land. So everybody worries about complying with the Planning Act, because if you don't, your deed isn't worth the paper it's printed on. There is an exception, and that is if your agreement of purchase and sale says that it's made subject to compliance with the Planning Act, then the agreement of purchase and sale itself will be valid. That's why there is a clause in the agreement of purchase and sale that says Planning Act. And what it says is this agreement is only valid provided that the Planning Act has been complied with. That's the purpose of that clause. It's to satisfy the requirement of subsection 21 of Section 50. So let's talk about the prohibition. What can't you do? Subsection 3 of Section 50 is the basic prohibition. And what it says is this, and it's in your materials: no person shall convey land by deed or transfer, grant or assign or exercise the power of appointment. Ignore that, it's old news. No person shall convey land by deed or transfer, or mortgage or charge land. So you can't transfer land, you can't mortgage land. You can't even enter into an agreement of sale and purchase of land. That's why the agreement of purchase and sale has to be conditional on compliance, because if you don't comply with the Planning Act, the agreement of purchase and sale is no good. And then it says, as a catch-all, or enter into any agreement that has the effect of granting the use of or right in land, directly or indirectly by entitlement to renewal for a period of 21 years or more, unless. That's a mouthful. But what it's saying is you can't give somebody the right to use land for a period of 21 years or more unless you comply with the Planning Act. Now, what does it mean, enter into an agreement that has the effect of granting the use of a right in land by directly or by entitlement to renewal? A lease gives somebody the right to use land. Let's say you're a farmer and you want to lease land for 30 years from your neighbor. Okay, a 30-year lease exceeds 21 years, obviously. Unless the Planning Act was complied with, it would be invalid. A 10-year lease would be valid. A 10-year lease with 2 options to renew for 10 years each. 10 plus 10 plus 10 gets you to 30 years. Even if you don't exercise the options to renew, that lease is no good from the beginning because it was a lease that provided for the right to use land directly or entitlement to renewal for 21 years or more. It's a good exam question. You know, they give you a question like that and you say, is it valid, is it not valid, depending on the situation. The renewal stuff is a cute little question, okay? Now, what kinds of documents would be the kinds of things that would grant a use in land? Rights of way, easements, leases. So essentially, any agreement involving the right to use land or the ability to acquire an interest in land is covered by the Planning Act. That's why everybody worries about it. Now, you would say, well, if everything is prohibited, how do I then make a deal? There are 6 major exceptions. Section 50 sub 3A says you do not worry about Planning Act if your land is on a plan of subdivision. That's why I spend so much time talking about plans of subdivision. Plans of subdivision are the way land is divided that has been approved by the government. Okay, remember this is government control of land division. So you can't put on a plan of subdivision without getting approval from the government. The government has agreed or approved of the way all these lots are created. But make an asterisk beside that point because we're going to be talking about something called part lot control in a few minutes. Okay, so your land is on a plan of subdivision, you are exempt. Okay, the next exemption, which is the most important, and that is you do not own any abutting land. Now, 3B is really lengthy. It says you don't own the fee or equity of redemption in any land abutting the land that you're dealing with, blah, blah, blah. What it means is you do not own any abutting land. So let's talk about how this works with my diagrams, okay? I own a big hunk of land, big parcel of land. I am not on a plan of subdivision. Make a note. When you're looking at an exam question, first thing you look at, is this land on a plan of subdivision or not on a plan of subdivision? Okay, that's your first thing to think about. We are not on a plan of subdivision. I own parcels A and B. When you're doing a Planning Act issue, always make a picture. Pictures help. They make sense because we are now looking down on the property. I own A and B. I want to sell B to you. I can't do it because when I transfer B to you, I own A. By transferring B to you, I would be dividing my land. That would be a contravention of the Planning Act. Okay? Simple rule. If I own A and B and I want to put a mortgage on B, I can't do that because I own abutting land. Now, this is a similar example. I own A and B. I've got a house on B. And I want to mortgage the land that my house is on, but I also own the vacant property next door. And it may be that I bought this property in 1990 and this property in 2000. Previously, they were separate properties. According to the law, it doesn't matter whether they were separate properties, separately conveyable before. They are considered to be merged under single ownership. So if I want to put a mortgage on B, but I don't want to put a mortgage on A, the Planning Act says I can't do it because it says no person shall charge land if they own any abutting land. Or put it differently, unless they don't own any land that abuts the land that they are dealing with. The Planning Act is a nasty piece of business. Okay, let me tell you, one section of one statute, I wrote a book on it. Okay, there's lots of old law on it. And let me tell you how lawyers make mistakes. I own A. I buy B. When I buy B, I want to give a mortgage to the bank to finance my purchase. Watch what happens. I own A. I buy B. I give a mortgage to the Royal Bank for $100,000. That mortgage is void. Why is that mortgage void? Because when I gave the mortgage on B, I owned abutting land. It doesn't matter what the history of the property was before. I dealt with land at the same time that I owned abutting land. Yeah?
What do you mean you gave a mortgage to the bank? Doesn't the bank give a mortgage to you?
No. The mortgagor gives the mortgage, gives the security. The bank lends the money, but the grant of the security interest is given by the owner in favor of the bank. So I'm the one that gives the mortgage. I'm the one that signs the mortgage in favor of the bank. Okay, the bank is the mortgagee. Remember, mortgagees have money. They're the ones with the dough. Okay, so terminology, it's the chargor, the mortgagor that gives the mortgage, grants the security interest. The bank does not sign a mortgage. Banks never sign mortgages. They just get the mortgage security from the borrower. Okay? So everybody clear on that. Now, there were schemes that people tried to get around this problem, and there were, and we'll talk about them in a bit. One of the things people want to do, let's say I own A and B and I want to sell A and B. I want to sell A to you and B to you. What we would do is we would say, you know what, I got a good idea. When I do my conveyance, I don't want to retain ownership of abutting land. So what I'm going to do is I'm going to meet you at the registry office and I'm going to meet somebody else at the registry office at the same time. I'm going to meet you guys. And what we're going to do is I'm going to drop my deeds on the desk simultaneously so that at no time do I retain ownership of abutting land. With me? Okay? The court said that's okay. Subsection 15 says, and it's in the materials, you cannot use simultaneous conveyances in order to breach the act. Another way of doing a deal, and this was a scheme, so it'll make sense as you're going through the material. I own A and B. I want to sell B to you. I want to keep A. I want to make sure I get this right. I want to keep A. So what I do is I sell A and B to you. I sell A and B to you, and you give me a mortgage on all of A and B. You own the property. I have a mortgage on all of the property. I then sue you for foreclosure. Okay? And I only sue you for foreclosure on A, on part of the land. You, of course, don't defend. I get a judgment for foreclosure. I register my foreclosure on A. You've got B. I own A. And we have gotten around the Planning Act. Subsection 18 says, no person shall use power of sale or foreclosure unless they deal with all of the land described in the mortgage, or unless these were whole lots on a plan of subdivision. But essentially, you cannot use foreclosure or power of sale in order to get around the Planning Act. Okay? Subsection C says you don't have to worry about the Planning Act if you are selling to or acquiring from the Crown. That means if the municipality is giving or getting part of your land while you own abutting land, there is no breach of the Planning Act. And that's because, of course, this is all about the province or the municipality controlling how land is divided. If they are parties to the division, again, that is permitted. Subsections D and E, ignore them. They come up very rarely. Those are for flood control projects and energy transmission lines. The last major exception is 3F, and that is if you obtain a consent to the transaction. So, if I own A and B, and I want to transfer A to you or mortgage A to the bank, and I have no other exception available, I have to obtain a consent. What is a consent? A consent is permission issued by a committee of adjustment or a land division committee or a council of a municipality approving the transaction. Okay? And sometimes you'll hear people talk about a severance. I'm obtaining a severance or a severance consent. That, in fact, is the same thing. Okay, just some other examples on how the Planning Act works. Rights of way. In this silly example, I own B and you own A. Your property has a little pond on it. I have cows. That's a cow. I have cows that are thirsty. And I say to you, would you grant me a right-of-way over the southerly 50 feet of your property, we're farmers, so that my cows can come and drink? You say to me, how long do you want? I'd say, well, I'm a young guy. I'm going to farm this property from now till eternity or sell it with the farm. I'd like a perpetual easement for the purposes of the passage of me and my farm animals to get to the pond. In that case, you would be granting to me a right to use land while you retain abutting land, the balance of A. In that case, you would need a consent to the transfer of the right-of-way. Okay, everybody still with me? Mutual driveways are an urban example of this. I own D and B, and you own A and C. We each have this real skinny little driveway that's a pain in the neck to get our cars in. Each one of them is 7 feet wide, and we say to each other, you know, it would be great if I could drive over yours and you could drive over mine. So we agreed to create a mutual driveway. Everybody know what a mutual driveway is? It's a shared driveway between houses that often you see them in the city. So what would happen is you, that's you, owners of A and C, are going to transfer to me a right-of-way over a 10-foot strip of property. At the time that you grant this right-of-way to me, you convey an interest in C, a right-of-way over C, you retain abutting land, you require a consent in order to make that conveyance. I would need exactly the same thing to give you a right-of-way because at the time, I'm transferring a right to use D while I retain abutting land B. Lands that abut. In this example, I own A, I buy B. I want to put a mortgage on B. Do A and B abut? The answer is no. They do not abut. Lands do not abut at a corner. Okay? But if there is any degree of abutting, regardless of how minimal A and B there, they abut. And I had a file where a lawyer client owned A, which was a house, bought B, and gave a mortgage to the bank. The amount of the abutting was about 5 feet. That was the extent of it. And of course, when this mortgage went into default, the bank said, whoops, we have a Planning Act problem because this mortgage is invalid because when it was given, the owner owned abutting land. So you have to be very careful about looking at, now, here's again why your materials are deficient. How would you know whether they abut? The only way you would know they abut is by taking the legal description and reviewing it with a survey. Because the survey shows the boundaries of the property, and it also shows the boundaries of abutting land. Okay, next, let me see if I've got any other good slides here. Yes, VTB mortgages. Okay, I own A and you own B. I am going to buy B from you. And I need $100,000 is the purchase price. I'm going to give a mortgage of $60,000 to the bank. I'm also going to do a vendor take-back mortgage for $15,000. Do you understand what a VTB is, a vendor take-back mortgage? Yes? No? No? Okay. This is practical. You own a house. You want to sell it. I want to buy your house. You're very anxious to sell, and I say to you, look, I really want to buy the house, but I've only got 25,000 bucks. And the bank will only lend me 60. I'm short 15. You're in a buyer's market, so you're dying to sell this property. So what you would say is, you know what? I'll do this for you. You give me 25, get your 60 from the bank, and me, the owner, will lend you the other 15. Now, I'm not going to lend it to you, but what I'm going to do is I'm going to take a vendor take-back mortgage. I'm going to sell the property to you, and you're going to give me a mortgage with the promise to pay me $15,000, let's say in 2 years or 3 years. And as security for my promise to pay you $15,000, you put a mortgage on the house. So the vendor transfers the property to me, Royal Bank mortgage goes on title, and I give a vendor take-back mortgage. It's a mortgage given back to the vendor for $15,000. It's a second mortgage. Okay? Now, just hold on. Now, what happens is, of course, I already own this. I buy this. That's okay. The RBC mortgage for $60,000, I own abutting land. That mortgage is no good. It's void because at the time I gave the mortgage, I owned abutting land. What about the vendor take-back mortgage? The second mortgage for $15,000. Subsection 8, I believe, says the Planning Act does not apply to vendor take-back mortgages. So in this case, the Royal Bank mortgage would be void, and the $15,000 second mortgage would be valid because at the time that the mortgage was given, it was strictly a vendor take-back mortgage, a mortgage given by a purchaser to a vendor to secure the purchase price. There were some questions. All gone? Nope.
Who would have priority with the VTB versus the bank in the case of default?
In the case of default, practically speaking, okay? In the case of default, practically, legally, the VTB is in first position, the Royal Bank is no good, okay? But what would happen is the insurer for the lawyer, and all lawyers have insurance, would hire somebody, maybe like me, to fix that mortgage. And there are provisions in the Planning Act, Section 57, which allows you to validate a contravening document. And on this situation, you could probably get a validation of title to validate that mortgage. And what the Act says is when you validate a mortgage, it's deemed never to have contravened. Okay? So there is provision for fixing, but you don't want to make those mistakes in the first place. Okay, now, I got to talk about part lot control. Okay? This is subsection 5. Remember I told you if your land is on a plan of subdivision, then you have an exemption under subsection 3. If you read subsection 5, I'll come back to leases. If you read subsection 5, it says, where land is on a plan of subdivision, that's the opening line, where land is on a plan of subdivision, no person shall deal with part of a lot on a plan of subdivision unless they don't own any abutting land or unless they get a consent. Same basic rules. So what it means is that if you are dealing with the whole of a lot on a plan of subdivision, you do not worry about Planning Act. If you are dealing with part of a lot on a plan of subdivision, then Planning Act still applies, because what you're doing is, with part of a lot, you're dividing up the lot that the government previously approved as a conveyable parcel of land. So, in this case, this is the easy example. All of Lot 1, all of Lot 2. I've now built semi-detached houses on each of these properties. If I want to sell Lot 1 to you, or mortgage all of Lot 1, let's say I want to put a mortgage on so I can build this property, can I put a mortgage on Lot 1? The answer is yes, I can, even though I own Lot 2, because my land is on a plan of subdivision, fits within the exception under sub 3, and I'm not dealing with part of a lot on a plan of subdivision. I'm dealing with the whole of a lot on a plan of subdivision. But after I built the houses and I want to transfer part 1, remember this is the whole of Lot 1, now we're on an R plan, on a reference plan. In order to be able to register, I need a reference plan of survey. I've got a reference plan of survey and it says, this is part 1, this is part 2, this is part 3, this is part 4. I want to transfer part 1 to you. Well, I need a consent to do that, because when I'm transferring part 1 to you, I'm dealing with part of a lot on a plan of subdivision. I own abutting land. Still with me? God, I hope so. Okay? Part lot control, remember, you are dealing with part of a lot. Do you own any abutting land? If you do, then you've got to comply with the Planning Act. Now, it used to be that we had this little inconsistency. Let's say all I own is I own this piece, I own part lot 2, and I own the east half of lot 1. I own parts 2, 3, and 4. I want to sell part 2 to you. This is a little tricky. I want to sell part 2 to you. I'm dealing with part of a lot on a plan of subdivision. I own abutting land. You would say, well, you can't do that because you're dealing with part of a lot, you fit within subsection 5. Now, if I said, okay, fine, I'm going to sell all of lot 2 to you, then I can do that because that's the whole of a lot on a plan of subdivision. So if I can sell all of this separately, why can't I sell this? Do I have to sell in order? Sell this first because it's the whole of a lot on a plan of subdivision, and then this piece because it's the remaining after I sell off parts 3 and 4, I don't own any abutting land. The Planning Act, subsection 5A, right at the end, says that abutting land, you can own abutting land if it is the whole of a lot on a plan of subdivision. Okay, so if I own just part 2 and all of this lot 2, I can sell this piece because my abutting land is the whole of a lot on a plan of subdivision. But if I only own this and this, 2 and 3, I can't sell 2 because I'm dealing with part of a lot and my abutting land is not the whole of a lot on a plan of subdivision. Your materials have this in it. That's the illustration. Now, it's not just with semi-detached houses. It could be any kind of an orientation of properties. Just understand, part of a lot, you're subject to Planning Act unless your abutting land is the whole of a lot on a plan of subdivision. Yep?
So you can get around that by selling 3 and 4 accounts, then later on sell 1 and 2, right?
Well, remember, if you're dealing with the whole of a lot, lot 1 and lot 2, doesn't matter about abutting lands because they're whole lots on a plan of subdivision. If you're dealing with parts, you always have to worry about Planning Act unless your abutting land is, assuming you own abutting land, unless your abutting land is the whole of a lot on a plan of subdivision. Next, subsection 4 says you can have land on a plan of subdivision, but the municipality has the power to pass a bylaw that deems a plan of subdivision not to be a plan of subdivision for the purposes of the Planning Act. So you may be the whole of a lot on a plan of subdivision. This picture isn't relevant yet. You may be the whole of a lot on a plan of subdivision, but the municipality says, we don't like the way we allowed the division of land, so even though you may own lots 1, 2, 3, 4, and 5 on a plan of subdivision, it is deemed not to be a plan of subdivision, so you cannot deal with lot 1 by itself. You own abutting land. Okay, that's subsection 4. Subsection 7, and that's the part lot control exemption bylaw. Let's go back to this guy. Okay, we're on a plan of subdivision, and I'm building semi-detached houses. And I intend to convey part 1 to you, part 2 to you, 3 to you, 4 to you. I would need a consent from the municipality. The municipality has the power to pass a bylaw that exempts land from subsection 5, from part lot control. And what they do is this. They say, from this day on, subsection 5 doesn't apply. So you get your exemption by virtue of the fact that your property is on a plan of subdivision. So you can sell part 1, you fit within the exemption in 3, your land is on a plan of subdivision, and subsection 5, part lot control, does not apply. This allows a builder of semi-detached houses on part lots to sell out his plan of subdivision. And ordinarily, when a municipality passes one of these bylaws, they put a sunset date in the bylaw so that the bylaw is good for 3 years, gives the builder time to sell off his lots to a bunch of buyers, and then part lot control kicks back in again. Okay, I got to move. I hate to say it, I got to move. There is an exception in the rule on, and it's in subsection 5 if you're dealing with part of a lot, that if you are dealing with part of a lot on a plan of subdivision, and the owner of the other piece of that lot happens to be a body that has the power to expropriate, then Planning Act doesn't apply to the dealing with the land. Let me explain it. I own lots 1 and 2. Under the Planning Act, I can deal with lot 1, I can sell it to you, I can sell lot 2 to you. I don't worry about it because I fit within the exception of 3A. My land is on a plan of subdivision. What if the municipality came along and said, we want to expropriate, or we want to widen the road, and we want 10 feet off the frontage of your house? So you do a deed, I do a transfer to the municipality for the southerly 10 feet of my property. Now look what's happened. I only own part of lot 1 and part of lot 2. I cannot sell part of lot 1 to you or part of lot 2 to you because I own abutting land and I'm not the whole of a lot on a plan of subdivision. The exception in subsection 5 says if I own part of a lot on a plan, the other part of which is owned by a body with the power to expropriate, Planning Act does not apply to my dealing with the rest of lot 1. Basically, it's like I've restructured the boundary of the lot, and that's simply because the municipality has approved of the way the land is divided. Now, we've talked about simultaneous conveyances, mortgages, wills. Wills is a good scheme. Let me tell you about a great scheme. There was a guy in Niagara Falls who, what he did was he said, I've got this big hunk of land, and I want to divide it up to make it look like a plan of subdivision. The municipality didn't like that plan of subdivision. They said, no dice. We're not going to let you do that. So what he did was he went to the local nursing home And he found Mr. Preston, who was not very well. And he said to Mr. Preston and his family, I'll tell you what I'm going to do. I'm going to give you all of my land. And I'm also going to give you a free will. And the benefit of the free will is, under the will, when you die, you're going to transfer lot 1, 3, 5, 7, and 9 to me. And you are going to transfer lots 2, 4, and 6 to my wife. And I'll let you keep, and do this for the whole subdivision, I'm going to let you keep lots 14, 16, and 12. Okay? So you can transfer that to your family. The prohibition in the Planning Act has been very strictly construed. No person shall convey by deed or transfer, mortgage the property, or enter into an agreement to use land. It did not say anything about devises by will. Okay? A devise by will is a transfer that occurs immediately in accordance with the will on death. The courts had routinely said dividing land in a will, like the north half of my farm to my son Joe and the south half of my farm to my daughter Betty, that was okay because that was not fitting within the precise prohibition of the act. So this guy said, whoa, this is a good idea. I'm going to use a will with guys that I know are going to die real soon, like within a week after he did this will. And they went to court on it because the town of Niagara-on-the-Lake was not a happy camper. The court said that the devise was valid because there was no prohibition against it based on decided law. But the court also said that these are not lots within the meaning of the zoning bylaw for Niagara-on-the-Lake, so they couldn't be built on. The legislation was changed. The Planning Act was amended. I think it's subsection 20 or 21, somewhere in there, that says you cannot use a will to divide land improperly. I really got to run through this real fast. Timing, okay? Timing is important when it comes to Planning Act. Prior to 1967, people were making Planning Act mistakes all over the place. They passed a law in 1967. Any mistake under the Planning Act that was made before 1967 is cured. It's valid, even though the Act said it's invalid. Prior to 1970, land was only subject to Planning Act if the municipality passed a bylaw invoking Planning Act, invoking subdivision control. So prior to 1970, you had to look to see whether or not there was a bylaw that related to Planning Act for the land. 1970 onward, all land in Ontario was subject to the Planning Act. Okay, and you'll see in the materials that we talk about that. The validity of consents. Okay, this is important. Subsections 12 and 13 and 14. Okay, and it's in the materials. I'm really zipping along because I don't want Reuben to accuse me of... What's that?
It's really hard to
follow?
Yeah.
Yeah, it is, because I'm going fast. Ordinarily I would do this in about an hour and a half, and I apologize, but we got tons to cover. I'm trying to give you as much of the overview as I can. Once you go through the materials, again, go slower? Okay, I will go slower. Okay, where'd you get lost?
At 1970.
Okay, all right. Until 1970. Yeah, if I'm going too fast, like... No, she says I'm good. Okay, look, 1970. Here's the issue of timing. When does Planning Act start to apply to land? Okay, because this is going to be an issue when it comes time to buy today. How far back do you have to search to see if there's a Planning Act breach in the chain of title? Remember I told you land titles absolute is subject to Planning Act. Registry is subject to Planning Act. LTCQ is not subject to Planning Act for any date prior to the date of conversion. So you're always wondering, how far back do I have to search to see how good my title is? Planning Act is just this little offshoot about title searching. You can search your title till you're blue in the face. If you don't find a Planning Act breach, your title is no good. The PIN, the parcel register, may say the property is owned by Joe Blow. It's owned by Joe Blow unless there was a prior Planning Act breach, in which case Joe Blow doesn't own anything. Okay, so that's the issue. So how far back do you search? Until prior to 1967, any breach of the Planning Act was cured. So you never have to search back before 1967. Think about it. That's over 40 years ago. And you're looking at title back 45 years to see whether or not there was a Planning Act breach. That is sick. Especially when the government says to you, oh, land titles, we guarantee your title. Look how easy this system is. Just search and the PIN says Joe Blow's the owner, except for Planning Act, which means you've got to go all the way back. How far back do you go? If the municipality passed a bylaw invoking Planning Act, you have to search back to 1967, unless you're going to have later dates in which to search back. Okay? If they never passed the bylaw, you have to search back to 1970. The specific date is in your materials. Because in 1970, all land in Ontario became subject to the Planning Act. Okay? Now, I'm going to switch gears because I got to. Subsections 12, 13, and 14. Subsection 12 is what's called the once a consent, always a consent provision. Makes for an easy exam question. Okay, this is what it says. Where land is conveyed with a consent, you do not need a consent for any further dealing with the identical parcel of land. Okay, now, here's where we go with this. I own A and B. You own C. Okay, I own A and B and you own C. I get a consent to transfer B to you. Because I owned abutting land, I needed a consent. You now own B and C. You want to put a mortgage or you want to sell B. You own abutting land. Do you need a consent to convey B? The answer is no, because when the land was conveyed previously with consent, it obtained the seal of approval by the municipality. And they say once land is conveyed with consent, you do not need a further consent to deal with the identical parcel of land. Now here's the nasty part. I owned A, transferred B and C to you, transferred B to you with consent, you own C. B was conveyed with consent. You say, I want to sell C. Can I sell C? And you would say, logically you would say, well, wait a second. If B is separate, then certainly C is a separately conveyable parcel of land too. It's logical, right? That's not how the Planning Act works. Planning Act says when you sell C or mortgage C, you own abutting land. C was never conveyed with a consent. So you, owning C, mortgage it, sell it, you breach the Planning Act. Because there's no exception that says you can deal with land if your abutting land was previously conveyed with consent. That's subsection 12. The municipality has the power to stipulate a consent. This is how this works, and this is the last lines of subsection 12. You'll read it and you'll understand it now that you hear how this works. Let's say you own A. I own B and C. We're not on a plan of subdivision or it's part lots. I own B and C. The way our houses work, you would like to buy the west 5 feet of my property. You'd like to buy C. So I say to you, okay, fine, you pay for the consent and I'll get a consent and we'll treat the conveyance of C as an addition to your property. That's a lot addition. Municipality says, well, wait a second. If I grant this consent and you convey this to A, this becomes a separately conveyable parcel of land because it will be land previously conveyed with consent. We don't want to have a 5-foot strip of property to be like a separate property. We want it to merge with A. So the municipality in granting the consent has the power to stipulate that subsection 12 will not apply to further dealings with the property. Okay, that's the right to stipulate. Craig, what am I missing?
What if I got, are you finished with that point?
Yeah, keep going, because I know you're going to take me somewhere. What?
So what is, instead of getting a consent to convey C, I got a consent to mortgage C.
A consent to mortgage C, subsection 12 does not apply to mortgages. Subsection 12 only applies to conveyances of land with consent. Okay, so you would have to look at the consent, and the certificate of consent is registered on the transfer to see whether or not there is a stipulation in the consent clause, and it's something that's stamped or given by the municipality that says, we hereby consent to this transaction, but subsection 50 sub 12 shall continue to apply, shall not apply to any further dealings with the property. They stipulate that it is a one-time consent only. Lawyers, never mind, I won't go there. Yes, at the back.
Is it fair to assume that once consent is given, consent is always open unless stipulated otherwise?
Correct. And subsection 13 says that. Subsection 13 says, unless it is stipulated, subsection 12 applies for all future dealings on the basis of that consent. Subsection 14 says, and this is another cure-all, where land has been conveyed or mortgaged with a consent. Where land has been conveyed or mortgaged with a consent, every prior breach of the Planning Act is deemed not to have prevented the creation of an interest in land. What it means is every prior breach is cured. Okay? So, in terms of how far back you have to search for Planning Act, if you find in your search of title a conveyance or a mortgage with consent, anything before that is cured. You don't have to search behind that for Planning Act. If a property was sold in 2000 with a consent, you don't have to search back to 1970 as long as that consent, that property was conveyed with that consent. Next, and we're getting close to the end. Subsection 22, the Planning Act statements. Subsection 22 says, where a grantor signs a transfer with a statement that says that they are not breaching the Planning Act when they transfer the property, and the lawyer for the grantor signs a statement that says, I'm not breaching the Planning Act by transferring the property with this, my vendor is not breaching the Planning Act by signing this transfer. And the purchaser's lawyer signs a statement that says, I have searched the title to this property, and I have searched title to abutting owners, and I am satisfied that there has never been a breach of the Planning Act with respect to this property. Then those three statements under subsection 22 cure all prior conveyances. Okay? The Planning Act statements, and I will show you later what these three statements look like in a transfer. When I do closing documents, I have more show and tell for you, and I will show you what those look like. So, what do you search and how far back do you search? Because I really am, as I say, plumb out of time. How do you search? You search not only title to your property, but you search all of the owners of a land that have abutting boundaries in order to make sure that at no time that your owner owned the property did that owner also own abutting land. Okay, that's what you search. How far back do you search, or do you search at all? Number one, if you are dealing with the whole of a lot on a plan of subdivision and it has not been deemed deregistered by bylaw, you do not search Planning Act. Okay, because you're on a plan of subdivision and you are not dealing with part of a lot. If your land was previously conveyed with consent that is unstipulated, and you are dealing with the identical parcel of land, you do not search Planning Act, because you can deal with the identical parcel of land because of subsection 12. Otherwise, how far back do you search? You search to the most recent of the following: a transfer with the 3 statements, because any breach prior to that's been cured, subsection 22. The date of conversion to land titles. LTCQ says that your land, your title, is good, and it accepts paragraph 11 of section 44. Remember I said that section 44 has a bunch of qualifications, one of which is Planning Act? Well, when they convert, they exclude paragraph 11, which is the Planning Act qualification. So you only search back to the date of conversion. That's at the back.
Sorry, when you said the date of conversion to LTCQ, does that also encompass LT and LT absolute?
No. No, only LTCQ. Because LT absolute did not have qualifiers. Remember that thing I gave you? LT absolute did not have qualifiers. LT plus, you only search back to the date of plus. LTCQ is LT plus is a converted. Okay, you take an LTCQ and you make it a plus. And what they've done is they move the date up from the date of conversion to the date that it goes plus. Okay? You search back to any transfer or mortgage with consent, because subsection 14 says you only search anything prior to a mortgage or deed transfer with consent. Everything prior to that is cured. If you can't find any of those guys, you are searching abutting owners back to 1970, 1967 if the bylaw was passed before 1967, or if between 67 and 70, the date the bylaw was passed. Now, that is Planning Act, as good as I can do in 50 minutes. Hopefully it helps you. You can now understand why I wrote a book. Okay, Craig, I think it's Craig. Craig, we're going to do off-title searches, and then we're going to break for well-needed lunch. I'm around for questions. I know that you will have all kinds of questions for me. Thanks.
Okay. So this topic is off-title searching. When Sid was talking about searching the title to the property, why are you searching title of the property? You're trying to determine if the title of the seller is good, and you're also trying to determine if there are any encumbrances. Remember, you get good title, free of encumbrance. That's what you're entitled to get. How do you know if your title is free of encumbrance? You have to do a title search to determine what the encumbrances are. Leases, mortgages, things like that. But there are other kinds of liens. Remember, you get title free of all mortgages, liens, and encumbrances. What are liens? Liens are generally government charges against land. So what you have to do is you have to find out if there are any government charges against land. The only way you can do that, because they don't usually register them on title, occasionally they do, but generally they don't have to be registered on title, so you have to write to the municipality, you have to write to the government, you have to ask them, do you have any liens against this property? And if they come back and say, yes, we have a lien against the property, you're entitled to title free of liens, so you can require the vendor to get rid of the lien. So I'm going to just go through the chapter and just give you a brief description of each of these things so you understand the context and what they're really getting at. The first one actually that I want to talk about is in the prior chapter, and that is executions. What is an execution? If I owe you money and I don't pay you, you can sue me in the courts. You get a judgment against me for that promise. How do you enforce that promise? You get an execution. The court gives you an execution, which effectively means that all of my land in that jurisdiction is charged with that damage claim, whatever land I own. So an execution is a lien against property in favor of an execution creditor. You have to do a search, and when you do that search in the land title's office when you're searching your title. You ask them if there are any executions against this land, and the land title's office will tell you if there are any executions. If there are, you're entitled to title free of that lien. You can demand the vendor removes it. Okay. All right. Next thing is realty taxes. The Municipal Act says that realty tax arrears are a lien against the property. It's not registered on title. It's just, that's what the statute says. So you have to write to the municipality and say, does my vendor owe any realty taxes? The municipality writes back and says yes. If they say yes, then it's a lien on the property, and you say pay your realty taxes. Okay, that's all on that. Water, the local municipality, if there are arrears on the water account, under the Municipal Act, can add those arrears onto the realty taxes. So it becomes like a realty tax lien. It's there for a lien on the property. You write to the municipality and say, are there any water arrears? Okay, so far so good. These are government liens on the property that don't show up on the title search. Okay, local improvement charges. I don't see this very much anymore, but if the municipality was installing, say, a sewer system in the road that benefited adjoining lands, they could charge those costs of the sewer system to the adjoining landowners through a local improvement charge because they're improving the locality. And what the deal would be is that you would pay that cost of your share of the septic system or whatever it was over, say, 30 years because you didn't have the money to pay your share right away. And that would form a lien on your property, local improvement charge. If you ever run into one of them, it's, the question is, can you require your vendor to pay for the next 25 years? There's some law on that, and it's really a matter of contract. Hydro arrears used to be a lien on the property. Ontario Hydro and the local hydro authorities used to be able to get a lien on the property, but that has been removed by statute. They do not longer have a lien on property, so you really don't care. However, because we're old and we change our views slowly, a lot of lawyers still write for hydro arrears and complain about them, and the answer to that is they're not a lien. Take a hike. Gas arrears, the gas people do not get a lien on property for arrears. You do not have to search for your vendor's arrears of their gas charges. Same as the hydro. Zoning compliance, the municipality has zoning bylaws which tell you what you can do with your real estate. It tells you how large a house you can build. It tells you what your floor area is. It tells you what your side setbacks are. It tells you your use. You can only build a residential property on this land. You can build an apartment building on this land. So your ability to use the property the way your client intends to is dependent on what the zoning bylaw permits or doesn't permit. So if you're It doesn't show up so much in the agreement, but you then would write to the municipality and say, tell me what the zoning is for this property, and does the property I'm buying comply with the zoning bylaws? You pay a big fee for that, $100 or whatever it is, and you get a response back that is totally useless. It doesn't help you at all. So this is a nasty area for lawyers. In a commercial deal, you would not take on this responsibility. You'd say to your client, that's something you have to do. Work it out yourself. Your client can go down to the municipality and can figure out whether its property complies. If you have a survey and you send the survey to the municipality, some municipalities will tell you, based on the survey, whether it complies with at least the setback requirements for the municipality. Any questions on that before I move on? Yep.
When there isn't compliance with the zoning bylaws, what's the effect on title?
Well, remember there's a clause, the title clause says good marketable title, right? But it also talks about insurability against fire and use. So if you don't comply with the zoning bylaw, you can't legally use the property the way you intend to use it. So you can then requisition it and complain about it. It's not a lien. It's your use. Thank you. Okay, legal nonconforming use. Remember I talked about that. That is if your property does not comply with the current zoning bylaw, but it's grandfathered, that's a legal use. It's just you can never change it. So it's a limited value use. That's not something you can search for. You have to figure out when the house was built in 1920. What was the zoning bylaw in 1920? Did it comply in 1920 or not? It's a bit difficult to do. Okay, work orders. The municipality has control over the condition of your house. If it's dangerous, if it's unsightly, if it's Sid's house, they will pass rules saying fix it up, or we'll fix it up, and if we fix it up, we'll add it to the tax roll, and then the cost is a lien on the property. Plus, if it costs you $10,000 to do the work, the municipality will spend $50,000 doing the work. And they will give you a very short time frame to do it. You'll have to fix it in 30 days, or they'll be out there with their 5,000 people painting your house. So you can, again, you write to the municipality and ask them whether there are any work orders, and they will tell you. And I just say, Sid's going to talk about title insurance, because title insurance basically says, these are small risks, a lot of these things. We will insure over them. You do not have to write your letters and spend your money, because all these things cost money. This is a huge money grab by the municipalities. They charge ridiculous fees and often give you nothing. Okay, the electrical safety. I'm not going to really talk about that. This is just it's another form of work order, depending on the for the stuff that they're dealing with, but that's not that important. Fire protection. There's a fire code. If you don't comply with the fire code, the fire department can issue a work order, and you have to comply. So this doesn't really, is not, nobody really does these for residential, but for commercial, it's a big deal, doing these fire code issues. The problem is when you ask the fire department if there's any work orders, if it's a commercial building, they go out and do an inspection, and guess what? They find a million things wrong with your building. So in commercial, you don't want to write for fire code approval. You want to hire somebody, a consultant, to go in and actually tell you whether it complies or doesn't comply. Occupancy permits. Municipalities have the right to say, your building sucks, you can't live in it. So that's obviously a big deal in residential. So you can ask the municipality whether there's an occupancy permit for the house. And this usually comes up with when you get approval from the municipality to build a house. They have rights of inspection. They have the right to do a final inspection. They won't issue an occupancy permit unless they've done a final inspection and approved your house. And many builders forget to do the final inspection, so the house doesn't have an occupancy permit. There is a case where the lawyer didn't search for an occupancy permit, client moved into the house, and the house fell down. And the lawyer was found liable for not searching for the occupancy permit. Unregistered hydro easements, this is another stupid area. The Ontario Hydro has the right to put hydro lines across rural properties, have nothing registered, have inadequate records. And so you could buy a rural property and have one of these unregistered hydro easements running across it. It's a very unsatisfactory issue because you write to them and the information you get back is fairly useless. So it's a real problem. The good news is normally you will see hydro wires running through the property, and that's an indication. Bankruptcy, if you go bankrupt, the property by law goes to the trustee in bankruptcy. You wouldn't do a bankruptcy search in residential. You'd do it, not everybody does it for commercial. Waste disposal search, if the property, the environment has, and local municipalities have records of whether properties were used as garbage dumps or waste disposal sites, you can ask them and they will tell you you don't want to buy a property that was formerly a garbage dump. However, these searches are also completely inadequate and the information you get back is unsatisfactory. And so in commercial, you would refer this to consultants to try to figure out. Heritage designation, if you have an old house, the municipality can designate it to be of historical value, which means it cannot be renovated, torn down, or except very restrictive rules. So you don't want to own a heritage house unless you're prepared to spend a lot more money fixing it up. And you can write and find out which properties are designated for heritage or not. Corporate status, if a corporation owns property and they lose their corporate status, it's as if the corporation died and the property would escheat to the Crown. So the theory here is that all land in Ontario is owned by the Crown. You don't actually own any land in Ontario. What you have is a bundle of rights called fee simple, which gives you akin to ownership, which gives you the right to sell it, the right to tear it down, subject to zoning bylaws, the right to convey it to your heirs. It gives you a bundle of rights that are very similar to ownership, but you don't actually own it. The Crown owns all land in Ontario, subject to this, your fee simple rights. So when a corporation, in effect, dies by losing its charter, the property becomes owned by the Crown. Just like if you die and you have absolutely no heirs anywhere in the world, the land reverts back to the Crown. And there are rules for unwinding it and blah, 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 blah. So you have to check all of your corporations subject to LCTQ, which corrects some of this. You have to go and find out if any of the corporations in your chain of title existed throughout the ownership of the land. You would not do this for residential. Compliance with registered agreements, if there are any agreements on title, such as shared cost facility, an easement agreement, subdivision or things like that, you want to know if they're in good standing, because if they're not in good standing, you may or may not be liable for those defaults. So that's something you would check into. In terms of municipal agreements run with the land. Some of them can be enforced against purchasers. Some of them can merely be enforced against the land. But you can write to the municipality and say, I'm buying a lot in this plan of subdivision. There are a bunch of obligations on the developer to create sidewalks and infrastructure. Has the developer complied with their obligations, or am I going to get stuck down the road for those arrears? And the municipality will tell you whether they're whether they're complied with or whether the municipality has sufficient security to ensure that the municipality can do the work. I'm running out of time. Okay, airport zoning regulations. Basically, if you're around an airport, there are height restrictions on how high a building can be. So you can't build your building above those height restrictions. Development charges is like other municipal agreements. Environmental searches, my recommendation to you, and you're doing commercial, is you're probably going to have to do some environmental searching, but to the extent you can, you should pass it on to your client's consultant. There are rules about underground fuel storage tanks, and they're a real disaster. Okay, then there's a section in your book dealing with special rules about farms and cottages. The real big issue here is the quality of water, because in farms and rural properties you usually have well water, and so generally you would have the right to send a sample of the water in to be tested to see whether it's clean water or not. So your contract will deal with that. In terms of wells, not just the quality of the water is important, but how much water is taken up, the flow rate, how much the water is replaced. And there are well driller's certificate. When the person who drilled the well did it, they've done testing, and they have to record how good the well is, and you can check that. Septic systems are really important in rural and cottage properties to check to make sure that it's being approved and licensed. There are cases where the septic system is merely a big, pit underneath the cottage. That's not obviously a septic system. And the only other one that I think that is really important, and they don't actually get to talk too much about it, is conservation authority. The local, if there's a river or stream in your property, the conservation authority has a lot of control over what you do in the watershed and the floodplain. And this really arises out of 1952 Hurricane Hazel, which basically wiped out a number of quite a few houses in Etobicoke that were built in the Humber River watershed. And as a result of that, they're very strong about not building in the floodplains. Okay?